Hi, I'm James, and this is my report on forensic linguistics by Olson. We will talk about authorship comparison and evidence in court. When we compare authorship of text, we must go beyond descriptive qualities and look into linguistic structures. At the deepest layer, there is syntax. When the layer is deeper, the less accessible it is to the writer's awareness and harder to imitate. Hence, the syntactic layer is more useful for forensic purposes, if not significant, than what we see at the surface layers. Example, spelling, document layout, and so on. This is the authorship comparison method. First, check known, questioned, and unknown text for compatibility and comparability. Second, examine text for points of similarity and difference. Do not be one-sided. Include counterexamples. Third, ascertain the linguistic layers or levels of these points of similarity and difference. Fourth, look for relationships between the different layers. Then, using a corpus, test the extent to which these features exist in the general population. Next, determine their relative significance in terms of an order of importance table. And quantify the differences using a statistical approach. And last, apply a scale of judgment reflecting the likelihood or unlikelihood of authorship. We'll have authorship attribution, comparison, or identification. Because forensic texts are typically short, they represent only small samples of human behavior. Even if we find that several short texts by one author exhibit similar features, we cannot be sure that these features are not random. There is always the possibility that some quirk of individual variation is acting on the features we have found. When using the term authorship attribution in the context of any type of text, short or long, one cannot use it in a technical sense. This is why it is suggested that the most appropriate technical term for authorship testing is authorship comparison. Some linguists use authorship identification. It is very rare in authorship work that one can identify a writer. Also, note that identification here suggests being able to pick out one individual author from all other authors. This takes us back to the linguistic fingerprint claim. This is another reason why Olson thinks the term authorship identification should not be used in forensic work. One of the key problems with authorship comparison is that some of the methods are not methods at all, and they have no theoretical underpinning. They are simply discursive feature sets. This is especially true of some stylistic approaches where the analyst is free to cite whichever features he finds unusual, which seem significant. However, it is important to have a reason for what we find significant, and that reason needs to be underpinned by a theory of individual language use. For this purpose, I propose that we consider the theory of markedness. But what is markedness? Markedness originated in structuralist and generative grammar as a way of explaining constraints on grammatical rules. In generative grammar, the way the child acquires language is explained by saying that there are two settings for any given rule, a marked setting and an unmarked setting. The unmarked setting is preferred because it requires the least informational input. The marked setting is used to provide contrast. The child usually chooses the unmarked setting. This can lead to errors if a child generalizes an ill-formed structure from a pattern. For example, seed instead of saw, on the basis that past tense verbs in English are most often formed by adding the morpheme -ed. This is why it is quite useless to correct very young children, because they are choosing the incorrect setting because as yet they do not have sufficient information to choose the correct one. The point about markedness here is that it is a version of some linguistic sign or structure which stands out because it is unusual in some way or non-standard. Unusual means a lack of conformity to a common pattern. This is Chasky's application of markedness. The first linguist to consider markedness in terms of authorship systematically was Carol Chasky, whose statistical analysis of syntax in authorship has met the Dober challenge in the US court system. She uses head-driven phrase structure grammar as a model. Like all generative grammars, it is based on the minimum number of rules. One of them is known as the specifier head rule. This rule states that a specifier should precede its head. A simple example of this is the word order of determiner plus noun in English. We do not routinely find phrases like dog da because this would violate the specifier head rule. If we did find a writer frequently producing such formulations, this would be a marked syntactic form. Chasky's method of authorship comparison involves the use of a software program called Alias, which implements a patent-pending proprietary way of calculating markedness across the heads. The user checks the tags of the speech parts, but does no more than that. Instances of markedness relate to the specifier head rule, the head complement rule, the head modifier rule, and so on. They can apply to noun phrases, verb phrases, or preposition phrases, adjective phrases, and so on. Once a text has been marked up for syntactic markedness, the results are computed statistically. In addition to syntactic markedness, punctuation in conjunction with syntax can also be used to evaluate authorship. This involves measuring how an individual uses punctuation. Punctuation can occur at word level, at phrase level, at clause level. Punctuation also occurs at word internal level, like in apostrophes or dashes. Markedness and authorship, a case history. The comparison assumptions would be, when comparing known with questioned texts, do not treat Q as a single corpus, since you cannot know in advance, if ever, whether all of Q is of a single authorship. The background to case. This case concerned a number of malicious and threatening letters. The recipients reported receipt of these letters to the police. It rapidly emerged that all of the recipients had something in common. They were witnesses in a rape case. They didn't actually witness the alleged rape, but they claimed to be in a position to testify as to the location of the main suspect on a particular day. Other individuals who were not witnesses knew of several visits by the victim to the suspect's house or knew of other information which was damaging to the suspect or perceived by him to be damaging. The letters all contained claims supposedly made by a friend of the suspect that he, the suspect, did not rape the victim. At about the same time, the rape case suspect himself wrote several letters to a number of the witnesses and others, effectively making the same claims as the questioned authors and in very similar language. I will now give some examples of the language of both text groups, the known and the question. There are two known examples, K1 and K2, and two unknown examples, U1 and U2. In these examples, the rape suspect is Joe and the victim is Mary. Text K1, known 1. I was arrested and charged with the rape of Mary. I could not believe this as I am and was impotent. Text K1, known 2. When I was arrested, I was firstly charged with raping Mary. I stated to the police that I could not rape anyone as I was impotent and had been since 1996. Text U1, unknown 1. The good fortune is Joe was able through solicitors, police, forensics, and medical experts to prove 100% that he could not and did not rape or have unlawful sex through his being impotent and is and has been for 5 years or more. Text U2, unknown 2. Neither would have known that Joe was to enter hospital to have tests to proving that he is and was impotent. The application of markedness. This is the table for references to impotence in known and unknown texts. For K1, the projecting clause is I could not believe this, while the projected clause is as I am and was impotent. For text K2, I could not rape anyone, and the projected clause is as I was impotent and had been since 1996. For text U1, Joe was able to prove that he could not and did not rape is the projecting clause, while the projected clause is through his being impotent and is and has been for 5 years or more. For U2, the projecting clause is neither would know that Joe, and the projected clause is that he is and was impotent. What the author finds curious about these examples is the tense inversion. The projecting clauses are in the past tense, but the thematic verb of the projected clause is in the present tense. This is a marked structure since it is more usual to cite events in their chronological order, and the projecting clauses themselves are in the past tense, and it would be more usual that the event nearer the projecting tense in time is mentioned first. This kind of disordering also occurs at the syntactic level in the present case. Thus, we have a syntactic break caused by punctuation or a comma in these examples. The police officer dealing with the case stated that he did not believe me. Second, no proof of sexual activity having taken place between Mary and myself. Third, I and my partner have over the past years and months studied the case. Here, we have punctuation breaks occurring at syntactic boundaries, but not at boundaries where they are licensed to occur. Each of these three examples clearly illustrates how we can use syntactic punctuation as part of an analysis. Let us now then look at the lexical level. A number of words were made into two words by the introduction of a space between them. For example, in both known and unknown, we find intercourse rather than intercourse. Example, for known, at the interview, the police withdrew the charge of rape and substituted it to one of unlawful sexual intercourse. The question, Joe was again interviewed by the police. The rape charge was dropped and changed to one of unlawful sexual intercourse. This is a disorder of the structure of the lexis seen in both K and Q. Other examples of which include photocopied, backfired, otherwise, and somewhere. As with the punctuation breaks in the sentence, we are seeing here a break, a word space, where one is not expected or licensed by the grammar. Based on the matching of the unknown and known text, we can see that there seems an unusual combination of common feature, which gives us the result that they match. Some types of match are more important than others. Thus, exact matches of long clauses or whole sentences would have more value than misspelling matches. Document layout and style would have the least value, even less than orthographic matches. For example, if a candidate and the known author both spell receive as RECIEVE, this may indicate markedness, but it is not likely to be significant markedness. With syntactic markedness, we are on surer ground than studying features at a more superficial level, such as document layout. We know that as speakers, that in English, the form dog the is marked because it violates a simple, easily observable grammatical rule. The next question is calculating the similarities and differences. To do this, compute the number of mark constructions for each type of phenomenon, syntactic and otherwise. It is also important to list counterexamples. Recall that it is not the linguist's task to prove anything. This is why it is necessary as well to include the unmarked. Judging the results. If one has adequately tested the results and the method and was able to quantify them statistically, one can repose a high level of confidence in them. Confidence here is being used in a non-technical sense. One tool used to assist in reaching a judgment is an order of importance table. This gives hierarchical order to markedness. This is the order of importance table of types of style features. The first feature is the types of grammatical structure, where significance depends on number and type of matches. Number 2 is punctuation. It can be significant but not necessarily in its own. The third one is the idiom. It depends on number and type of matches. The fourth is spelling, but one needs to research the degree of rarity. The last one is the document layout, but caution is required, example for US versus UK versus European styles. If we find two texts supposedly independently produced with a significant number of syntactic matches, then this is likely to be of greater significance than matches relating to document layout. The last step is to apply a scale of judgments. The scale will help to determine the level of confidence in the work. It is important not to overstate the confidence in the findings. It is just as important as being completely neutral and impartial, being rigorous in your method, using only the most tried and tested statistical procedures, and practicing the utmost confidentiality in the work. Further authorship testing. In many inquiries, we are dealing with writing which, superficially at least, appears to be very blunt. The example below will illustrate. I have spent some time this evening at your site and have not been able to access any material of the type that was used to advertise it. It was a bit like memory lane. Some of the material was lifted straight from 35mm films and videos that I watched 20 years ago. Seriously though, it really was nothing like the preview and I have no wish to subscribe to this type of site. Please, would you give me access to the type of material promised or cancel the charge to my card? Incidentally, I had no trouble with the photo archive, but what is one supposed to do with the new cam's video and erotic show sections? I was unable to get anything from them. In this particular case, the above email was found on the home computer of a businessman who denied authorship. He explained that a friend of his, a plumber since deceased, had written the email and even used his credit card to complete the purchase of the site membership. There was some difficulty obtaining letters written by the deceased who, according to his family, had never been much of a letter writer and had never owned a computer. However, some correspondence was obtained, and the following is a typical example. Known example of plumber's correspondence. Dear Mr. Brown, please could you contact me as soon as possible as to my situation at the moment and why I am being kept here at the prison, and when will I be released as not knowing is worst of all. I hope to see you soon. The above example shows a number of basic prescriptive errors, including being kept instead of being kept, and the termination of a sentence before end. Additionally, the plumber confuses the superlative with a comparative adjective. Example, worse instead of worst. He exhibits difficulties in grammar, punctuation, and lexis. On the surface, at least, his writing is not easily comparable to that of the email found on the businessman's computer. The businessman, on the other hand, demonstrates greater competence, as can be seen from the following text. Known example of businessman's correspondence. On Tuesday, 1 May 2001, my wife and I went out to dinner with my daughter and her partner. When I returned home at about 1:30, there were two messages on the answer phone. One was from the central station that monitors the alarm at Green Lake Street, Smithville, informing me that the telephone connection to the premises had failed. The second was from my PA, Mrs. Jones, who is an alternate key holder at Green Lake Street, to the effect that she had been informed of the line failure, had attended the premises but found no indication of anything amiss. I returned the call to the monitoring station and learned that the probable cause was a line fault and that the incident had been policed, log 101 time at 22:35, and that the police had attended and reported the premises to be secure. The analysis. The author began by looking for signs of markedness in the different known texts. At first sight, the businessman's text seemed to be very formal, perhaps even pretentious in parts. However, at this stage, this is just an impression and needs to be tested. Relative frequency is a sign of markedness versus unmarkedness. Some forms of markedness are purely stylistic. Example, the use of excessive repetition. As such, they are hard to measure and can only be used for an impressionistic account of authorship. In the present instance, the author decided to take an internet and corpus survey of the phrases found in the known and questioned texts and test them for frequency. All of these phrases were surveyed on Google and samples of these were rechecked using the British National Corpus. Further checking of some of the samples was done using CoBuild. Theoretical considerations. I will summarize this chapter by saying something about theoretical basis for a discussion on authorship. Style. Style can be generic. Example, the style of a particular genre, or it can be personal. Example, the personal style of an author. However, description of superficial style is simply not adequate for forensic purposes. Markedness. Markedness occurs at many levels, formally and informally. it is important to link different types of markedness to try to understand the underlying system of markedness for a particular author or set of texts. We should also consider that in some sense, all texts are marked. Idiolect. We cannot assume that just because we can differentiate the authorship of different writers, individual writers have an idiolect. The way in which we acquire use of a language socially and continue to modify it through education, peer usage, and the media all mitigate against the idea of idiolect. Stylistics. The use of descriptive stylistics for forensic purposes is simply not acceptable in today's scientific climate. In recent years, courts have rightly insisted on more formal approaches which should wherever possible be quantifiable, either in terms of probability or classificatory statistics. This time, let us proceed to evidence in court. Legal requirements across the globe. America. The United States of America basis for admission for expert testimony called the Birth Criteria Knowledge and Stature. The expert must have sufficient knowledge of the subject area. Additionally, the expert must have stature in the academic or other peer community. First, testing. The technique must be empirically tested. The review. The technique must have been subjected to peer review and publication. Scientific method. The expert must be able to demonstrate the known error rate. Straightforwardness. The technique must be able to be explained with sufficient clarity and simplicity so that the court and jury can understand its plain meaning. Australia. The emphasis in Australian law has now been placed on the requirement to be relevant and reliable. Expert witnesses are not required to provide the kinds of scientific evidence. Rather, they are obliged to qualify their findings where they believe there may be incomplete or inaccurate evidence, and they must give reasons for their opinions. This implies, of course, that Australian law does not exclude experts from giving their opinions. However, in several countries, lawyers are reluctant to accept linguistic evidence because many believe themselves to have adequate linguistic knowledge to form their own opinions. England and Wales. Wolfe contended that the use of experts could contribute significantly to a case cost and therefore deter individuals from seeking legal redress. He has proposed the appointment of a single expert for both parties. In those cases where the parties are unable to agree on an expert, Wolfe proposed that the court itself should make the appointment. His aim was to give courts wide-ranging discretionary powers in the matter of experts. The calling of expert evidence should be under the complete control of the court. Canada. In Canada, the determination as to whether an expert witness should be called was formulated as early as 1931 with the memorable juridical phrase, "The subject matter of the inquiry must be such that ordinary people are unlikely to form a correct judgment about it if unassisted by persons with special knowledge." Expert evidence must be both helpful to the court in its role as trier of facts and relevant. France, Germany. In France and Germany and other countries which follow an inquisitorial legal system, experts are appointed by the court, not by the parties to a case. The investigation is carried out by a judge or panel of judges. Lawyers acting for each side submit questions the judge may ask the witness. In the inquisitorial system, evidence is much more freely evaluated. Last, other countries. In the Philippines, the rules of evidence with reference to expert witnesses state that the opinion of a witness regarding a question of science, art, or trade, when he is skilled therein, may be received in evidence. That ends my report. Thank you for listening.